An email appears on the screen showing email correspondence from Judge Albright. Sections are highlighted showing Mike's request and the judge's response. Mike. Document sent via email in OCR compatible format. Due to my visual impairment, I can't read printed materials. I can read electronic materials in OCR compatible formats with my electronic devices. Judge Albright. Allowed. Other highlighted text reads, Mike. No threats, intimidation, and coercion. I have PTSD, and threats, coercion, and intimidation can cause me to shut down and not be able to function and communicate. Judge. Allowed as required in all cases. Mike. A visual interpreter to interpret and relay all visual information at trial. I am visually impaired and unable to have live access to visual information without an interpreter. Judge Albright. Denied. After conferring with the Administrative Office of the Courts, there are no certified visual interpreters. However, Mr. Nelson will be allowed to bring any personal assistance of his choosing. See below. Below is Mike. Use of personal assistant as auxiliary aid in the hearing. This person will be able to communicate to the judge when they notice any time my disabilities are making it difficult to communicate. Also, with my brain damage, I have memory loss, and my auxiliary aid will be able to remind me of what my defense strategy is. Judge Albright. Allowed. So, Mike clearly explained the role of his chosen auxiliary aid, and by separating the request from the request for a visual interpreter, he made it clear that this aid was not serving in that position. Judge Albright clearly granted the accommodation to send documents to Mike digitally in a format his screen readers could read. The judge also agreed that he would not use threats, coercion, or intimidation during the proceedings. Let's listen to how that actually played out in court.
I'm going to give a waiver of counsel to Mr. Simmons. Mr. Simmons, if you'll go over this with your client. Sheriff, you'll give this to Mr. Simmons. What? Excuse me?
I'm sorry, Your Honor. He doesn't want me to accept that.
You don't have a choice. You're here on his behalf. I'm giving it to you. I'm not.
With all due respect, Judge, he's not here on my behalf. He's not representing me. I'm representing myself. He's my auxiliary aid, so he works at my
Sheriff, give that to Mr. Nelson. Give that to Mr. Nelson. It's fine.
I can't read whatever paper you're handing me, Judge. I can't accept that.
Okay. That's fine. I'm still giving it to you. Please
If you could send it to me in an OCR format, I believe that was one of the accommodations.
I'm giving it to you right now. Mr. Nelson, I'm giving it to you right now. I'll take it with Mr. Simmons, and I'll do the best I can to get it to you in another way. Take it, please.
Judge,
wait a minute. Do you refuse to take that document?
we had an agreement, Judge, that you would send documents to me in OCR compatible format, and I can't read physical paper. That was what my request was for. All documents to be sent to me in OCR format.
Mr. Simmons, review that document. You're hereby ordered to review that document, Mr. Nelson.
Mike reminded the judge of this interaction later in the proceedings when Mike was presenting his arguments in support of his motion to dismiss based on lack of due process. A motion in which the sitting judge, Stuart Albright, was named as one of the chief violators of Mike's rights. Note: Judge Albright did not recuse himself from ruling on whether or not he violated Mike's rights.
Federal code on coercion, threats, and intimidation is 42 U.S.C. 12203. It also, in there, explains that it doesn't just pertain to the person with a disability, but any person that is accompanying that person and is assisting them to be able to enjoy equal access. So that, in this case, that extends to my auxiliary aid, Mr. Simmons, and the order this morning that Judge, when you ordered him to read and be my interpreter, I would say also falls in line with that federal code, Judge.
All right, Mr. Simmons, did you feel intimidated or threatened when I asked you to do that?
Well, it was an order.
In any event, your motion, I note that your stated reasons regarding your assistant with regard to threat and coercion are denied on his face and without merit. Based on what your assistant just told me, he's not been intimidated. I find that as a fact, or threatened or coerced. With regard to your concern and objection to the court with regard to reasonable accommodations, the court is, your motion is denied. It is meritless.